Today, we are going to discuss labor relations, the National Labor Relations Commission, or NLRC. It is a quasi-judicial body tasked with promoting and maintaining industrial peace by resolving labor and management disputes involving both local and overseas workers through compulsory arbitration and alternative modes of dispute resolution. It is attached to the Department of Labor and Employment for program and policy coordination. The NLRC handles cases involving labor disputes that cannot be settled through voluntary arbitration or conciliation mediation. Its jurisdiction covers, but is not limited to: 1. Unfair labor practices, ULP, as defined under the Labor Code. 2. Termination disputes arising from illegal dismissal claims. 3. Claims for monetary benefits such as unpaid wages, overtime pay, and separation pay. 4. Breach of collective bargaining agreements, CBAs, when grievance mechanisms fail. 5. Cases involving employer-employee relationships not subject to conciliation. And 6. Complaints or appeals from decisions of labor arbiters or regional arbitration branches. Unfair labor practices, or ULPs, are wrongful, prohibited acts committed by either employers or labor organizations that violate the workers' fundamental rights to self-organization, collective bargaining, and concerted activities. The following are considered ULPs by employers. 1. Interference with the right to self-organization occurs when employers restrain, coerce, or intimidate employees from forming or joining a union. For example, at Rivera Manufacturing, management warned employees that anyone who joined the newly formed workers' union would face reduced work hours or possible termination. Similarly, at Delgado Retail, the company offered salary increases and additional benefits to employees who agreed not to participate in union activities. These actions violate labor rights, as they create an atmosphere of fear and discourage workers from exercising their legal right to organize and bargain collectively for better wages and working conditions. 2. Yellow dog contracts or discrimination occur when employers require workers, as a condition of employment, to refrain from joining a labor organization or to withdraw from one. Additionally, discrimination in hiring, tenure, or other employment conditions to either encourage or discourage union membership is a violation of labor rights. For example, at Santiago Textiles, management dismissed several employees after discovering they had joined a union, while at Mendoza Corporation, only non-union members were considered for promotions, effectively discouraging union participation. 3. A violation of the duty to bargain collectively happens when employers refuse to engage in good faith negotiations with a recognized collective bargaining agent. This includes surface bargaining, where an employer pretends to negotiate but has no real intention of reaching an agreement, as seen in the case of Dela Cruz Enterprises, where management repeatedly postponed meetings and rejected all union proposals without meaningful discussion. 4. Contracting out to defeat unionization is another unfair labor practice, wherein an employer outsources or subcontracts jobs specifically to weaken union influence. For instance, at Reyes Manufacturing, long-term unionized workers were replaced by contractual employees, preventing the formation of a strong bargaining unit. Lastly, discrimination due to testimony or participation in unfair labor practice, ULP proceedings, occurs when employers retaliate against employees for filing complaints or testifying in labor disputes. At Torres Logistics, a warehouse supervisor was demoted after providing testimony in a ULP case, discouraging other employees from speaking out against unfair labor practices. These actions not only undermine workers' rights, but also violate labor laws designed to ensure fair and just employment conditions. On the other hand, ULPs by labor organizations or their agents undermine workers' rights and disrupt fair labor relations. First, coercion of employees occurs when unions force individuals to join against their will or intimidate them into membership. For example, at Santillan Auto Parts, union members threatened new hires with isolation and reduced workplace support unless they joined the union. Second, causing the employer to discriminate happens when unions pressure management to favor union members over non-members. At Del Mundo Supermarkets, union leaders convinced management to assign better shifts only to unionized employees while sidelining those who refuse to join. Third, refusal to bargain collectively is another ULP, where a recognized union fails to negotiate in good faith. At Gonzalez Shipping, the union representatives deliberately stalled meetings and rejected reasonable offers, prolonging disputes and preventing agreement. Fourth, excessive or unlawful dues can also be an issue, as seen at Navarro Textiles, where workers were charged initiation fees well beyond the legal limit, effectively forcing financial dependence on the union. Lastly, causing unjustified work stoppages disrupts business operations and violates legal labor procedures. At Castillo Manufacturing, a union-led strike over minor grievances without following legal requirements led to financial losses and strained labor relations. While unions play a crucial role in protecting workers, engaging in these unfair practices contradicts their purpose and can lead to legal consequences under labor laws. Section 8, Article 3, Bill of Rights of the 987 Philippine Constitution states that the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. Also, Section 3, Article 30, Social Justice and Human Rights states that it shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. They shall be entitled to security of tenure, humane conditions of work, and a living wage. A collective bargaining agreement, or CBA, is a contract executed between the exclusive bargaining agent, union, and the employer, setting forth the negotiated terms and conditions of employment applicable to all workers in the bargaining unit. The CBA must be in writing and signed by the parties. Once concluded, it becomes the law between them. A CBA has a maximum term of 5 years. However, the economic provisions must be renegotiated at least once in the third year of the agreement. Non-economic provisions usually remain stable throughout the full 5-year term, unless both parties mutually agree to reconsider them. Commonly included in CBAs are union security arrangements such as 1. Closed shop wherein only union members can be hired and must remain members in good standing. 2. Union shop wherein non-members may be hired but must join the union after a certain period. 3. Maintenance of membership wherein employees who are union members at the time of CBA signing must remain members for its duration. These clauses must be negotiated in good faith and must not violate employee rights or public policy. Collective Negotiation Agreement, or CNA, is a contract negotiated between an accredited employees organization as the negotiating unit and the employer management on the terms and conditions of employment and its improvements that are not fixed by law. An accredited union and the employer management can enter into a collective negotiation agreement. After a certificate of union accreditation is issued, and within one year, the union shall submit its CNA proposal to management. Upon its signing by the parties and ratification by majority of the rank-and-file employees in the negotiating unit, to be done within 90 calendar days. Otherwise, the application for registration shall be denied. Public Sector Labor Management Council, PRPSLMC. Resolution Number 2, Series of 1991 states that a CNA shall not have a lifetime of more than 3 years. The contract bar rule protects the incumbent union from being challenged regarding its accreditation by a rival union if there is a CNA in effect with a term of not more than 3 years. The employee organizations obliged to renegotiate the CNA within 60 calendar days prior to its expiration. The CNA incentive is a form of reward granted to both management and rank-and-file employees of agencies in recognition of their efforts in accomplishing performance targets at a lesser COSIT. What can be negotiated under CNA? 1. Schedule of vacation and other leaves. 2. Personal growth and development. 3. Communication system. Internal, lateral and vertical. External. 4. Work assignment/reassignment detail transfer. 5. Distribution of workload. 6. Provision for protection and safety. 7. Provision for facilities for handicapped personnel. 8. Provision for first aid medical services and supply. 9. Physical fitness program. 10. Provision for family planning services for married women. 11. Annual medical, physical examination. 12. Recreational, social, athletic, and cultural activities and facilities. 13. CNA incentive pursuant to PSLMC, Resolution Number 4, Series of 2002, and Resolution Number 2, Series of 2003. What cannot be negotiated under CNA? 1. Increases in salary. 2. Allowance. 3. Travel expenses. And 4. Other benefits that are specifically provided by law. Thank you very much.